familiar faces. Even if I can't see your face, I can see you that you're attending. So thank you all for joining this morning. And thank you to Vesta. I've had a long relationship working with Vesta and providing these legal updates all the way back to when I was a baby attorney, first coming out of law school, and really only practicing in this area now going on for 17 years as a condo HOA attorney, for better or worse. So this year, the legislative update. The good news is that there isn't as much that changed as we did maybe from last year. The other thing too is that it's largely condo focused this year in terms of the substantive changes. Now, what we're first going to talk about is going to be, changes regarding community association managers, management companies, and that applies to all community associations, whether you're a homeowner association, condo association, timeshare. Some of the timeshare stuff, I know we probably don't have many, if any, people on here that's in like a specific timeshare community. There are a little bit of differences there that if you have any questions, you can reach out to me afterwards on that. But largely, the changes on the CAM side apply to all associations. And then after that, we're going to jump into the substantive changes on the condo side. Now, for our homeowners association members, I know I see a lot of you on here too. Um, I want, if you have any questions from last year's legislative session, especially, I'm happy to help try to answer them in as best a way as I can, from a general standpoint. We've had kind of a year to let it digest, simmer, whatever you want to, term you want to use for it. Unfortunately, though, a year is too short of a period of time for us to have any, appellate decisions interpreting anything with the new statutes from last year. But certainly we had some substantive changes, especially on the enforcement side, is what I would say that we continue to receive, a lot of questions on. The other thing too is that even if this doesn't apply to you yet, like for a homeowners association, what happens a lot of time is that these changes may be implemented as to one side, in this case, maybe the condo side, that may be coming down the pipeline, for HOAs. So if it's not applicable now, it may be applicable in the next year or two. So kind of understanding what the legislature is looking at may help you. You may change your policies a little bit, even to kind of get ahead of the curve, even if you're not required to. So I want to mention that too. But largely, again, substantively, it's condo focused this year for the changes for community associations, aside from the manager side. So I'm going to share my screen here. All right, everybody should be able to see that. All right, so the bill we're going to be talking about is House Bill 913. It was signed into law by the governor on June 23rd, and it was effective as of July 1st. This was a little bit like a tighter turnaround. There wasn't anything, that I was aware of, and in speaking with people, lobbyists, anything else. It wasn't necessarily there's anything controversial here that led to such a short turnaround between when it was signed versus when its effective date. Sometimes it's a little bit sooner than we know. I think there was just other things on their plate, and that there was a lot of bills this year too, that it just took a while to get through them. So I wouldn't take anything to it that there was something, overtly controversial or anything with that. I just found it kind of interesting that, it was kind of a quick turnaround from when it was signed versus the effective date. All right. So first, we're going to be talking about, like I mentioned before, is the CAM updates for community association managers. It's applicable to condos, HOAs, cooperatives, any type of community association, because it's dealing with CAM licensing and management contract requirements. So for CAMs, a manager whose license is revoked may not hold an interest in or employment with a management firm for 10 years following revocation. Okay. So they've specified that it's kind of a strict, obviously, standard from a disciplinary standpoint. Managers must maintain an online account with the DBPR, and you have to update it within 30 days of any changes. That's important to note. Most managers probably are already aware of that, but there's some tying in here with the disciplinary side, and especially on the HOA side, you're required to list the associations that you're working with, so that the DBPR has a way in this last bullet point to notify associations and management companies if a manager's license is suspended or revoked. So keeping that information up to date on the manager side, and just understanding that there's that licensure and account requirement. So I've already seen this in looking at management contracts for communities that we work with. Management contracts are required to include a statement of compliance with professional standards. And the law states that a management contract cannot, contract around or waive those professional standards. It's a one or two sentence basically stating that management company and the managers agree that they will uphold the standards as required in the manager licensing statute. So it's not anything too in depth, but it is something that's required to be included in all the management contracts now. And obviously, making sure that you're operating and abiding by that. Managers may not knowingly carry out unlawful directions from an association and are held to duties of good faith, diligence, honesty, and full disclosure. So that's provided for in the statute. Um, Largely has been the standard already. This is now just more clearly defined. It's very similar to what the obligation is for a board member, right? A board member and officer, you're acting as a fiduciary. This essentially is establishing a fiduciary relationship and duty of good faith, diligence, honesty, and full disclosure to the members. You know, not knowingly carrying out unlawful directions, where that plays out practically is, speaking with our managers, and I know we have obviously a lot of probably mostly board members on here, is that there can be some times where there may be something that's asked of the manager that the manager knows is unlawful or that at least requires a legal opinion for further guidance for the association. And if a legal opinion is provided, for example, stating, hey, it's our opinion that this is not a proper action to take, the manager it has required to, not carry out anything that's unlawful. Now, managers aren't attorneys, right? And so that's where a lot of this comes from. But I think that's the main takeaway from this is the managers are held to a standard here that they can't carry out anything that's knowingly unlawful, right? Obviously, there's a lot of gray areas too, and most attorneys will tell you that, and it's rare that we can also provide a black and white opinion to an association either. But when it's clearly unlawful, they have an obligation to not act on that. Managers providing services to homeowners associations must attend at least one board or member meeting annually, provide and update contact details, their hours, their duty summaries for posting on the association website or the mobile application if it's required, if they have one, which, as a reminder that all HOAs of 100 parcels or more as of this year have to have a website. And the manager or the management contract must be available upon request. So you can't state, well, that's an official record inspection, make an appointment, and then within 10 business days, we'll have you come in and then you can inspect the management contract there. This is more of a quick reactive requirement of if you ask for it, you got to make a copy available right away without making them come in and inspect it. I was going to kick to just, I don't know how you could be a manager for an HOA and not attend at least one board or member meeting, but it's a requirement now. There's been some changes on the conflict of interest side. So it expands the definition of a conflict of interest involving managers, the management firm, officers, and their relatives. Basically, what it says is that there's a rebuttable presumption that a conflict exists if the manager or the management company enters into a non-management contract with the association or has a financial interest or receives compensation from a vendor doing business with the association. So an example would be management company obviously provides management services, but if they also have an arm that provides, site maintenance or janitorial services, something that's not providing management services, there's a rebuttable presumption that a conflict of interest exists. Doesn't mean that you can't enter into it. It just means that there are additional requirements. A more probably, you know, not as clear-cut case is the issue with having a financial interest in. So even if it's not clearly a such and such, branch of whatever company, if there's a financial interest or one of the officers has a financial interest, it can get into kind of a gray area. But if there's any relationship there, the better route to take here is just comply with this requirements. And it's not overly burdensome, in my opinion. It just needs to be properly disclosed and properly voted on, which we'll get into in just a second. So if there is that conflicted bid, right, which is what we're calling it, if there is some relationship there, whether it's the management company directly or if they have a financial interest in the company that's doing the work, if that bid exceeds $2,500, an association must solicit multiple third-party bids unless, and this is the kicker, unless the disclosure is made in the management agreement disclosing the relationship or those companies. And I've seen that before in management agreements where we'll say, here are affiliated companies or that we may, and I think as a result of this law change, it might need to be a little bit more specific perhaps. But if that is disclosed in the management agreement, then the competitive bid is not required. I mean, and the same thing on the next page. which is that the conflict related contracts must be disclosed on the board meeting agenda and approved by two-thirds of the board vote and disclosed to the members at the next regular or special meeting. Again, unless it's already disclosed in the management contract, right? The idea there being that board came in fully aware when it signed with the management company that there was this relationship and that these companies provide additional services and that they may be offering it. That kind of is the exception to the otherwise the disclosure requirements here. So again, if you don't have it in the management agreement, if it's more than $2,500, you have to get multiple bids. Doesn't say three, but that's usually the best practice. And it needs to be disclosed and approved by two-thirds of the board at a board meeting and disclosed to the members. One thing though that's interesting is if you've kind of followed with the last couple of years of legal updates is that on the board member side, we already have kind of similar language here that if a board member either owns is providing services or owns a company or has a financial interest in a company that's providing services, you got to go through kind of a similar process here, but the members have the ability to cancel that contract. That's not included here on the management side. So there is a little bit of difference on those conflict related contracts between, whether it's the board or the management company. If that conflict wasn't disclosed, then the management contract or the contract, I should say, that you're entering into may be voided through written notice from the board. And, I'd be concerned like from a disciplinary standpoint as well, because it's affecting, it's really the DBPR has oversight over that on the management side. So main takeaway from this is conflict disclosure, doesn't mean that you can't enter into these contracts. I'm familiar with many different companies that have kind of different branches that offer services other than management services. The key is just to make sure that it's open and you go through the proper steps to approve that. All right. All right, on the condo side, so let's jump into the substantive updates for condos. So one thing, as of up until I should say on or before October 1st of 2025, all condo and cooperative associations must create and maintain an online account with the Division of Condominiums through the DBPR. The division may require certain information be provided by the association upon 45 days advance notice. The association must provide contact information that includes the name of the association, the physical and mailing address, the email address and telephone number, the name and board title for each member of the board, contact information for management, and a link, like a hyperlink or website address of the association's website. So that's all required. Association must also include the total number of buildings, including the number of stories, the number of units, the age of each building, any construction commenced within the calendar year, the amount of assessments or special assessments by unit type, the purpose of the assessment or special assessments, and the name of the financial institution with which the association maintains accounts. So reporting requirement to the DEPR, right? And what they're trying to do is they're tracking here further, kind of going along, I think, with the partially at least related to the three-story and higher structural integrity reserve study milestone inspection requirement. I know that it's optional here. You can upload your structural integrity reserve study through this account. But by October 1st, you're required to have this account. I know that the DBPR within the last couple of weeks provided the link to that to go on and create that account and go through that process. Believe there's a step-by-step guide on their website for all the different things that you have to go through on this. But it is a requirement for condos and cooperatives that you have this done by October 1st. Again, only condo and cooperative, not required for HOAs. One thing is maybe people might not be familiar with is that the DBPR doesn't really have a lot of oversight over HOAs. It has oversight related to election disputes and any recall dispute. That's specifically provided for in the Homeowner Association Act, and there's provisions of the administrative code regarding disputes related to elections and so on. But it doesn't have oversight, for example, for use restriction violations or anything along those lines. May happen in the future. I know there's been discussion in recent legislative sessions about doing that, but it's a big expansion, really, of their oversight once you start including HOA. So I just want to give you all some background too of why that's not a requirement for HOAs like it is for condos. And I know that I'm also receiving some questions here too. I'm going to go through a little bit more and then I'll stop and I'll take some questions before we proceed on. So if you don't see me answering them, I'm going to get to them in just a little bit too. So on the milestone inspection side, not a lot in terms of any big substantive change. There are some additional obligations placed on local governments, local building officials. So the first part is that local governments are required to adopt ordinances for enforcement for post-inspection repair obligations. So what does that mean? Well, when you go through the three-story and higher, if you're a three-story and higher condo that had to have a milestone inspection done, the way that that works is you have what's called a phase one inspection and report, and that's more of like from a visual side. If the entity that you retain for that, whether it's an engineer or architect, says, hey, you know what, we need to get behind that further and we need to do a phase two inspection, and which then leads to a phase two report. Typically, that's going to lead to recommended repairs in some way. It's rare. I don't know that I've seen where a phase two inspection was done, but then not say that further repairs were required, because you can usually tell that visually from the phase one side. So, where this change comes into play is that up until this year, the statute says that a local government could adopt an ordinance requiring you to start repairs within 1 year of a report recommending repairs. Now it's obligating local governments to adopt that ordinance. I'm not sure that every local government's happy with this. I know speaking with people, but it's putting more on them to adopt this. So if you're a three-story or higher condominium that is going through that, or has gone through the milestone, or it's coming up soon, be aware of what's going on in your local government side to see if they've adopted an ordinance on that, so that you know that if you get a report back that recommends repairs, that you may have an obligation in reporting with your local government, your county, your city, whatever the case may be, because there may be an ordinance in place. So that's the big takeaway from that. The next couple points, and it's kind of again a theme on the conflict of interest, the disclosure requirements that the design professional and contractors that are handling the milestone inspection process must disclose if they intend to bid on repairs recommended by their own inspection, or if they have any ownership or familial ties to the inspection firm. The idea being, if you're an inspector, you're hiring an inspection firm and they're going to be providing you with recommended repairs and a report, they should tell you if they plan on bidding on that, because that may affect your, at least your perception of what that report's going to look like, if it makes it look like they're going to try to, say that the sky is falling and that they intend on repairing it. So just a disclosure requirement there, and that the failure to disclose renders a contract voidable and it's subject to disciplinary action. There's annual reporting by local enforcement agencies is required on the inspection progress and unsafe building status. So I know that in some of the counties that we work in, a lot of associations that fell within that three-story and higher requirement, they receive notifications saying, hey, you're on our list. We show that you're going to have this done. Please notify us when you're done so we can be part of the inspection and oversight process. So there's an annual reporting requirement now that's placed on local enforcement agencies. Like I mentioned before, on the requirement to adopt an ordinance, same thing with reporting requirements here. And then going back into the post-inspection services, whether it's the repair process or whatever, those contracts can be voided if the conflict disclosures are not made. Again, key is saying if I have a relationship related to the inspection of this building, which led to this recommended repair report, I need to disclose that if I'm also bidding on it. The other key takeaway from this too, and this is for the milestone inspection and for the structural integrity reserve study side, is that they clarified that 3 stories means 3 habitable stories. I know we spoke with some communities where they had a parking area on the first floor, there's no living space there, and then the 2 floors above it were habitable. Up until July of this year, we said, it doesn't say habitable, it says 3 stories or higher. So they had to go through this process. Now, with this change, they wouldn't need to. If you're in a community like that where you did go through this and now you're realizing that you don't have to have it, I would recommend talking to your manager and your attorney to see what you do with your SIRS that you've had done, with any reserve accounts that were set up. There's some steps to take there, but it is something that they've clarified, and a little bit of a question that came up a bit. On the insurance side, it was just more of like a clarification here that associations must maintain adequate property insurance, notwithstanding whatever provisions you may have in your governing documents related to insurance. And it's clarifying again that it's based on replacement cost as determined by an independent appraisal. You're all probably familiar in a condo that you have to have the appraisal done at least once every 3 years. It needs to be based on that. You can have it done more frequently than 3 years, but that's the longest you can go between appraisals that are done. So that's a big takeaway there on the insurance side. All right, I'm going to stop and just see if I have what questions we have here before I jump into some of our other topics. There's one question: is a manager or management firm required to divulge if an assigned manager has been charged with a felony? I'm not aware of a specific requirement. It wasn't part of the legislative changes. It would be something to look at in the CAM statute. So we'd have to take a look at that, but I'm not aware of, if that is a requirement to divulge it to the association. It certainly would be something that would be included as part of the licensing and may affect their license. But I'm not sure if they otherwise have a valid license and can operate as a manager. I'm not sure that there's a disclosure requirement. See, another question: is a manager allowed to use a name other than the name on the CAM license when performing contract duties for a client? Again, not sure. I'd have to take a look specifically. It's not something that changed as of this legislative session. I would imagine that you should be operating pursuant to the name that's on your license. That's what you should be utilizing. Subject to, I would imagine, if somebody, got married or had some reason to have a name change, something along those lines, and their account hadn't been updated yet. But beyond that, I would imagine there could be some issues if, using a completely different name and, there's some nefarious purpose or something like that. But it would need to, review the CAM statute there for any specific requirements. There's one question: what happens if the annual meeting does not meet quorum? There's only 12 units. Can we lower the quorum requirement in our documents? So in any case, either if you're in a condo, I'm not sure if you're in a condo or an HOA, you do have the ability to amend your documents to lower the quorum requirements. From the condo side, it says that your quorum is not required for your annual meeting as long as 20% of the owners cast a ballot. And that kind of, because usually it's quorum is a majority for a condo meeting. For HOAs, it's 30% or less. But I've especially, more often than the condo side and the HOA side, have amended their governing documents that addresses the quorum requirement to go lower than that. There's nothing stating that it must be at least, 10% or something. So that is something that you could look at in amending your governing documents. And once a person said it would be helpful to see all questions asked by attendees. I'm not sure if you can only see your own question. I'm sorry. I'll make sure to read them out though as I go through. One question was, is the DBPR for all condos and not just 3 stories and above? Correct. They have oversight over all condos and cooperatives. The only exception there is not so much DPR oversight, but more like the statutory, obligations for if it's like a non-residential condo, a commercial condo. There are some ways where those are not subject to the same requirements as a residential condo, but there still is DBPR oversight, if that makes sense. Let's see. I have a question here about HOAs with the architectural committees. I'm going to save that for later. What about condos that have retail space, not residential, on floors 1 and 2? So Perry, I think the answer to that is I'd have to look at the definition of habitable. It's not something that's been posed to us all that often. It's not very common to have that where you're kind of within that sweet spot of a 3 story, but maybe some of it is commercial space. I'm not sure if habitable is defined as, purely for residential purposes, or if it's being used obviously for people coming and going and it's being occupied and not just like a parking space, for example. So I'd have to take a look at that. That's a good question. Does the management company create and maintain the DBPR data and reporting? Frank asked that. I believe if that's in response to the October 1st requirement, that's something you should just talk with your management company about who's going to be taking the lead on creating that account. I would imagine probably it's your management company that would at least be working with the president, for example, of getting that set up and making sure, that the login credentials are all stated, in case there's any change in the future, that kind of thing. But I would think that the management company would probably take the lead on that, but you want to just confirm that with them. Then can the HOA board president verify and the view the DBPR account? Just like similar with that question that was answered, I think just working in conjunction with your management company. Certainly, though, it's the association's account, right? So management may assist, but it's the association's account that's being created. Let's see, is there a new law this year regarding HOA annual meetings that allows 10% ownership present at the meeting will trump the quorum requirement? No, there's nothing new for HOAs this year. Um, Chris, if you want to restate that, I'm not, but there's nothing new though in the HOA statute. One question, and then we'll keep going through the slides is how do you differentiate between a condo association and HOA? It's largely going to be when you look at your documents, condos are very specific as to how you can create them. It's going to have a visual depiction of the condominium property, a description of the units, and so on. That's very like every condo declaration has to have that information. If you don't have that, then you're likely going to be, it's under a homeowners association, which is largely going to reference your plat, which describes the land that's going to be subject to the covenants and restrictions in your community. So I hope that kind of helps answer your question. All right. All right. So let's keep jumping back in here. So on the financial and records requirements, this again, condo only. So associations with the website or mobile application obligation. So as a reminder, as of right now, still it's for any condo with 150 units or more. But as of January 1st of 2026, any condo with 25 units or more has to have a website or a mobile app that contains some of your official records, and there's a login requirement and all that. That was new that came out of last year's legislative session. So again, that's just a reminder of what the website requirements are. If you do have that requirement, there is the new change this year is that whenever you get a contract or a document that has to be posted on the website, it must be done within 30 days of receipt of that document, unless there's a different time frame as required by the statute. So 30 days is kind of the general rule. The takeaway from this, what you can see is if you have documents that have to be placed on the website, you have a time limit to do that. Don't wait too long. 30 days at the max. I'm not aware of anything that's longer than that. But the best practice is as soon as you receive it, make sure it gets uploaded so that there's no question about compliance with the website and posting of your official records on there. Approved minutes over the preceding 12 months are required to be posted to the association website or the mobile application, in addition to any affidavits that may be required by statute. I'm not going to go through all of them, but there are certain instances where affidavits are required to be posted by the association, whether it's for meeting notice requirements or notification to members of availability of financial reports, all of that. Just double check there. And with this official record requirement, the best way I can state it is that there's a long list of documents that are considered official records that have to be maintained by the association. Not all of those records have to be on the website, though. It's more of a truncated list so that you're not just throwing everything. Now, you can choose to put all of those records on there, and it does help. I can tell you from a record inspection process, if you have everything already available on the website, there's no need to coordinate an in-person inspection because you can just point them right to your website, right? But you're not required to post everything there. So I just want to make sure that that's clear too. The association, the board must use best efforts in investment decisions and may invest reserve funds without a unit owner vote in qualifying financial institutions. So some questions we received over the years is what are we allowed to do? Is there anything in the statute that says we can invest reserve funds or whatever funds the association may have in this, but not that, right? And the statute still doesn't say exactly what that is, but generally you're looking at money markets, CDs, safe investments, FDIC insured. And the best way to make sure you're protecting yourself, work with people that have expertise in this, right? You work with your attorney to get you a legal opinion, have a trusted banker and a lender that you're working with to give you, advice as to what's the best way that we can put this money to work until we need it. And as long as you're being prudent, you're going to be fine as a board member. The last part about not needing a unit owner vote, that's something that's already been kind of advice that's been given by, I know our firm and many other attorneys that I work with, that, we all kind of practice in the same area, that's been advice. This makes it clear that you do not require a unit owner vote. Year-end financial reporting requirements. It must include information on any loans, special assessments, and whether the funding aligns with the reserve study. So there's going to be more detailed requirements in your year-end financial reports that's kind of tracking along and listing any outstanding loans and special assessments and the reserve funding. So, and we're going to get to a little bit later on the structural integrity reserve study side, but kind of the takeaway from this is being clear that if you get a reserve study done, you need to be following that. And if you're going to deviate from it, you need to have a competing report that you can basically rely upon. This is kind of similar from the standpoint of, making it very clear if you're following along with what your reserve study requires. So from a day-to-day standpoint, this one is going to be probably one that impacts your community the most. Video conferencing. So if you're having Zoom, Teams, whatever type of meeting where there's a video conference component and board members and members can appear remotely, if you are doing that, you also have to include a physical location where unit owners can attend the meeting. Um, what that can look like is you might state, here's the link for the meeting. If you would wish to attend in person, here's the physical location for it. And then you got to have some type of a speaker there, a way for people to dial into the meeting so they can hear exactly what's going on with the people that are attending remotely. So that's a requirement there. Now it says video conferencing. Now, what if you had a conference call for a board meeting? Well, the statute says that board members can appear telephonically. And so arguably you don't need to have the physical meeting location if you take away the video part of it. I'm not saying I would recommend that, but I'm kind of pointing out the fact that they specifically use the word video conference. Um, it's one of those things that we've been asked since COVID, really, of having completely virtual meetings, and we've always said, well, we don't really have, specificity here. Here's where I can maybe support on the board member side, but what we run the risk of is somebody invalidating the meeting saying that you should have had a physical meeting location. This is now giving us that answer of if you're going to have a video conference, you got to have a physical place too that's listed on the meeting notice in the agenda. Now, I've been asked this too, though. This doesn't mean now that you're required to offer a video conferencing component. If you just want to have a fully in-person meeting and that's it, you're completely allowed to do that. There's no entitlement to an owner, to give like, hey, I can't be there. I demand that you set up a conference call line for me to call into. You're not required to do that. What this is doing is if you are choosing to have a video conference meeting, you got to have the physical location. The other thing too is that if you are having that video conference, you have to record it and you have to keep that recording for 1 year. If you have a website requirement, you need to post it to that or post like a link to the cloud where that recording is being stored. And it needs to be available for 1 year from the date that it's posted to the website or the mobile application. So like I said, probably this is one of the ones that's probably going to impact you the most on a day-to-day standpoint, because I know a lot of communities will have some type of a Zoom or Teams component to their meetings. Another requirement for the unit owner meeting side, so not a board meeting, but a unit owner meeting, it must be held within 15 miles of the condominium property or within the same county. That's still it's been the law for a while now. What they shrunk it down though was it used to be 45 miles within the condominium property or in the same county. Now it's 15 miles. So this probably impacts, I know I've spoken with some of you about this already, but if your management office is in a different county and maybe it's 20 miles away, that may be where you run into the issue here. Versus if you're going to have your meeting in the same county anyways, it doesn't matter. Annual meetings. So it's the same thing where if you're going to have some type of a video conference component, you have to have a physical location, but also, and I found it interesting that they required it for this, but not for a board meeting, that at least a quorum of the board must be physically present at the meeting location from the annual meeting side. So if you're going to have an annual meeting and you say, hey, you definitely have to have the physical location. I've already said that even before this law changed this year. But if you're going to have a Zoom side saying, if you can't show up in person, here's the Zoom link, then you need to make sure that at least a quorum of your board members show up physically at that annual meeting spot. The other thing they did, and we're going to get into voting a little bit later, it's not the exact same thing as we're talking about here, but that voting at virtual meetings may be conducted electronically if there are procedures that are followed. This is separate from the electronic voting statute. This would be if you wanted to somehow find a way to say, no, this is not for our election. This is for a vote to amend our bylaws or our declaration or something like that. And we want to be able to allow people to just raise their hand or cast their vote on Zoom or something like that. This kind of opens the door for it. You got to make sure, though, that you have procedures in place to safeguard. Okay, if you're going to vote virtually, I would want to adopt those procedures months in advance of the meeting so you can notify everybody. There are probably some registration requirements. You can verify that it's them, on their Zoom. So this just opens the door, though, for more virtual voting at virtual meetings. All right, so going back to the 3-story and higher. So again, it applies to habitable stories. Good question though before about if it's on the commercial side. I don't have a specific answer for you on that. Um, the catch-all. So in the statute, this is for both structural and non-structural. it will state that you have to have reserves for the following items. For the non-structural, it's always been your roof, your painting, your paving of your parking area, and then any other capital, replacement cost or deferred maintenance that is $10,000 or more. And the same thing on the structural side, which will list all the structural components, but then it'll say any other item that contributes to the structural safety of the building, something along those lines that exceeds $10,000 or more. Well, they raised that catch-all from 10,000 to 25,000. So if there was something that maybe was between 10 to 25,000 to repair or to replace, that may no longer need to be included as part of your reserve study. Probably not going to be all that applicable too often, but it is something to be mindful of. Reserve funds generally can be pooled together across required components as long as the pool balance meets the projected expenses. It's kind of catching up to what's already been the practice. Reserves for structural components. So this is one that we didn't have an answer on because the structural reserves are newer. They may be pooled together. So if you have a structural integrity reserve study, you can put all those funding into one pooled account as long as you can only use it though for those structural components. But you got to keep it separate from your non-structural reserves. Again, this is another one, this first bullet point. For a while, up until this law change, it was pretty much every condo attorney's opinion that if you're going to go from what's called straight line reserves, where you are separately categorizing each reserve item and having a fund balance for just that item, that if you wanted to take all those and put them into one pooled account, it would take a one-time owner vote. Now it says that it does not require an owner vote. It can be done by board vote to put them into a pooled account. They've expanded the ability for funding for structural reserves. It may be funded by regular assessments, special assessments, lines of credit, or loans. There are some exceptions to this. You can't do that if you're developer controlled or just turned over within the last year, or if you have a bulk assignee or a bulk buyer that's essentially kind of like a pseudo developer that owns units in the condo. You're not allowed to use this, but it's opening up rather than what I would say is the default process, which is you fund your structural reserves through your reserve funding, through your annual budget and your annual assessments. This would allow you the ability, to show that you've passed a special assessment to cover that funding, or that you've got a line of credit available, or that you've taken out a loan for it. I would again make sure that you work with your attorney to show if you say, hey, Ed, instead of us putting aside X number of dollars in our regular assessments, we think that this statute allows us to do this. This is what we're kind of planning, but we want to make sure that we're doing things correctly and we're not stepping foul, what the Condo Act requires. That's what I would recommend that you do, whether it's with me or any other condo attorney that you work with, right? Special assessments, here's the kicker though. So it's like I think, and I've spoken with people about this to see am I missing something here? And I was told, no, Ed, you're right. Like, and where I'm going with that is, okay, so they opened up the options for different ways to fund your structural reserves, but then they say that it needs to be approved by a majority vote of the total voting interests. So my issue with that is, well, what if your documents allow you to do some of this without an owner vote? Now you've just made it harder to access this, broader way to fund your structural reserves. You just made it harder for us to do that, kind of the opposite, maybe what you intended. I was told that there was one of our, state senators was very insistent upon this, that this language be included. That was my understanding with it. The members need to know. It's like, well, yeah, but the members know through their documents and what their documents require, right? So it's almost like one step forward, one step back a little bit, but we can deal with that. It does help though if it wasn't in your documents at all that you can fund it this way and it gives you, what the voting requirements are. There are some limited instances that if you get a milestone inspection done, what I believe this is meant to address is that if you have a milestone inspection done that's recommending repairs in the next couple of years, you can pause your structural integrity reserve funding for 2 consecutive budget years if the inspection report justifies it. So again, I want to make sure this is kind of a limited exception to your reserve funding requirements on the structural side. Just make sure that you're not missing anything. We don't want to run afoul and have somebody complain that, we violated the statute by not putting money aside for our reserves. But there's an open chance for it if it's in conjunction with an inspection that was done and what future recommended repairs might be. This is a big one. I mean, from the standpoint, I've had some discussions, is that an association must obtain an updated reserve study before adopting any budget that deviates from the current reserve funding plan. So this kind of answers the question of, boy, Ed, I've had this. I've had where I've got very smart people on the board, but they're serving as volunteers. They may be, retired engineers or architects or so on. And they'll say, I really don't agree with this. I don't think we need to put 100 grand a year aside. I think we're fine with 80 because I think that those numbers are off. Up until this law change, I would say, well, you might be able to, but how are you going to be able to justify? What are you basing that on, when you're deviating from it? But there was no legal requirement to stick to it. Now there is. If you're going to deviate from your reserve study with the recommended funding plan, you got to have a competing reserve study done that you can base it off of. The other thing too on the structural integrity reserve study requirement, they pushed back the deadline. So if anybody missed it and was worried, they were given a little bit of a reprieve until the end of this year. I think it was largely due to availability of engineers or architects or the qualified reserve analyst to get that reserve study done on time. We have a couple more slides left, and then I'm going to get through the rest of our questions here. So I know if we have some and I haven't answered them yet, I'm going to be getting to them in just a second. All right, on the hurricane protection side, the main takeaway from this is I believe that there must have been some issue. This is what happens a lot whenever laws are passed, right? Is because something happened and the legislature realized that they needed to either clarify or address something in the statute to fix an issue. And so probably what happened here was a condo association. There was a question about, well, owners are required to, if they want to put up hurricane protection, window coverings, shutters, and so on, that's fine. But what if we need to get through those items to fix condominium common elements that we are responsible for as an association? Who is responsible then for getting through those owner responsible items? Who's responsible for the cost of it? And what this says is that if the declaration is silent, and it's found that the removal of a hurricane protection item is necessary for the maintenance, repair, or replacement of other condominium association property that the association is responsible for. The board can determine if removal or reinstallation must be completed by the owner or the association, so the board can choose. But at the end of the day, the association is responsible financially, whether it's reimbursing the owner or if the association does the work, it's responsible for it. My takeaway from this, I don't know why you'd want to have an owner do that work and then you come back behind and do your own work. I would rather just control it if I'm going to be responsible for the cost anyways. But that's what this is really meant to address. If there's any kind of, if the documents don't address the issue, then this statute controls. All right, the other part, that I think is, and I've already, spoken with some communities regarding this for elections that are taking place after this law change. Again, condo only, electronic voting and ballots. So, first part is that if you want to adopt electronic voting, the law's been in place for a bit up until this year, and it is still the case though. So, this is a big distinction between HOAs and condos. For HOAs and condos up until July 1st, you would have to give 14 days mailed, hand delivered, or electronic notice of the board meeting where you're going to adopt a resolution regarding electronic voting. It's still a board vote, but you had to get that extra notice requirement, not just posting it 48 hours. As of July 1st, that only applies to HOAs. For condos, you can now just post it 48 hours notice. Hey, we're posting our agenda. And by the way, we're going to adopt a resolution for electronic voting. So it kind of eases the notice requirements if you're going to adopt electronic voting. One thing I don't have in here that I should have included if you want to write it down is that members can petition for the board to adopt electronic voting, but they have to do it within, I think it was either 90 or 180 days after the last annual meeting. So if you have an annual meeting, let's say there was no electronic voting, the members would have the ability to petition and require the board to adopt electronic voting, but they have to do it within a certain period of time. I believe it was up to 6 months afterwards. Otherwise, they waived it. You got to wait until next time. So it's the first time that members can kind of control getting electronic voting passed, potentially for consideration there. The bigger takeaway I would say from a day-to-day standpoint is not a lot of communities still have adopted electronic voting yet. If you have not adopted that and gone through that process, you must create an email address for receipt of electronically transmitted ballots. So this is now opening the door for owners to email their ballots for an election, and you have to accept those now. You might say, well, I thought ballots were secret. Well, yes, but owners can choose to waive the secrecy of those ballots. I think the intent behind this, my understanding, is that in recent years, I think we've all probably dealt with it. I've seen it a bunch of times where Association gets the second notice out. It has to be done at least 14 days. So maybe it's done on the 14th, 15th, 16th day, whatever it is, before it. But people weren't getting their second ballot package until like a week later or longer. It was taking a long time to deliver, and there was such a short turnaround to then get your ballot back. I think the intent here is for out-of-state people, people that aren't close by, to have a way to ensure that they can, instantaneously, practically, right, complete their ballot and then email it back to the management company if that's typically where it's going to go, and know that their vote's going to be cast and not that it's going to be delayed in the mail. So you have to create an email address that you'll tell people if you want to submit your ballot electronically, here's how you do that. That ballot, it has to include a space for the owner to type in. It says type in their name, but if they print it out and sign it and write their name in and then scan and email it back, that's even better, honestly. It's just the way that the statute's worded. But that serves as the owner's signature, even if they just type it in. There also is a disclosure statement that must be in all caps, large font. It has to be larger than any other font on there. Warning of the waiver of the secrecy of the ballot, and that's the owner's choice. You're not obligated to do it. I know one of the managers I saw who was on here. We kind of worked through. I kind of kicked around. Should you be sending out alternate ballots? Like, hey, here's your mail-in ballot, but if you choose to email it, here's the other one. Only use one of these. I've kind of come to a little bit more of creating one ballot and having your normal ballot language on the top, but then having almost like on the bottom quarter of the page or something stating that, hey, if you are submitting this electronically, here's the disclosure, here's where you must put your name and your unit number and everything, where now you've met the electronically transmitted ballot requirements, right? So that's, I think, practically the best way to handle it. The other thing too, just for our managers, especially because it's probably 95% of these are handled by the management company when you're dealing with the election, is that you must accept those electronically transmitted ballots up until the time of the meeting. We can't say, hey, our meeting's at 6 o'clock tonight. The cutoff for emailed ballots is 2 p.m. today. It says until the start of the meeting. And so what I've been advising is bring your laptop with you, make sure you've got an internet connection, and then you can check that email address that the ballots can be sent to, so that, if the meeting starts at 6, you do a last check at 6 o'clock, drag over any ballots that you receive into maybe some type of folder just for the purposes of the election, that you can then, as part of your vote counting, here are all of our paper ballots, and then let's go through the email ballots if you haven't already printed them out. So that's practically, I think, how I've been recommending that we handle it. Certainly, if you wanted to bring a portable printer with you so that all you're counting are paper ballots, that also would work. But this is something that um, a lot of communities, if you don't have electronic voting set up, you have to go through this process and notify people. And I would tell them in the second notice what the email address is. You don't really need to do it in the first because there's no ballot to send back yet, right? I would imagine that you'd be including that as, adding it in now as part of your standard package that you send out with your second meeting notice saying, here's everything, here's the ballot. If you're going to submit it electronically, here's the email address, and you got to fill out the bottom portion of that ballot, something along those lines. All right, I'm going to leave my contact information up. I know we've got a lot of questions, so I'm happy. And we've got a lot of them that's come up here. So let's get through them here. And if you have any more, I'll try to address them for as best I can, okay? All right, so George said for an HOA, the new law 723.035 regarding architectural committees visible from an adjacent common area or community golf course gives them almost total control for an HOA such as mine, where every parcel is visible from somewhere on common grounds or golf course. And the comment was that that's bad law. So I think what that law, George, was that what that is intended to address is that if there is something that might be technically a violation, but if nobody can see it, then the association can't enforce just because it's aware it might be there because somebody told them about it or whatever, right? The way that this came about was something to do with artificial turf and nobody being able to see it except for when they were first bringing it in to be installed. But once it was installed in the backyard, my understanding was nobody could see it from there. Why should it then be a violation? But I can see it making sense, though, that if just because, you might not be able to see it from one side, but if a neighbor can see it from their parcel and it's still a violation, you can still enforce your governing document. So that is something we continue to receive questions on, though, is when is that law applicable? You get into a whole issue of constitutionality and whether or not that law, when it effectively tries to prevent associations from enforcing their documents, can that be applied retroactively to contracts, covenants that existed at the date of the law change? there's a lot of arguments that can go into place there, right? But there's some common sense approach that if nobody else can see it, why are we going to be enforcing against it? How would we even know to enforce it, right? I had somebody joke about, well, what if I flew my drone up there and took a picture from it? Well, I would argue that you're kind of seeking it out there, right? The purpose is if I'm in my backyard and yeah, maybe somebody from the street can't see it, but I can still, I know I'm a tall guy, I don't know if you all know that, but like still, if I can see in and that's something that is clearly not allowed and I can provide evidence of that to the association, that should still be enforceable. All right. Peter said, regarding conflicts, can a condo president allow an owner, board member, or otherwise to be paid for physical work on common areas without disclosure and approval by the board? So if they're going to be paid, that would still fall within the conflict of interest disclosure. Because if you're either personally providing services that you're getting paid for, or if you have an ownership interest in a company, so that needs to be disclosed. The question then is, well, what about if, we just volunteer? That wouldn't necessarily have the same because there's no compensation. I'm always still, I always caution using volunteers in the community for work for liability purposes, workers' comp, all that stuff. Like, I would want to have some liability waivers and also make sure that you talk with your insurance agent before you allow, volunteer workers to do work on your property. It's just kind of a recipe for a potential issue down the road. But if they are getting paid, though, you would definitely need to go through that conflict disclosure requirement. Does the financial report notice have to be physically mailed out, or can you just post it to the website? So yeah, Diane, I think, and from an HOA standpoint, what it says is that you need to either send it out, a copy of it, or let them know that a copy is available upon request or that it's posted to the website. But you still, in any event, have to notify the members whether you're actually giving them a copy or send that out upon receipt of that financial report of how it can be made available. How often is a reserve study required? So Bill asked that. So on the structural integrity reserve study side, you have to have a new study done every 10 years. That's the only legal requirement for a reserve study in the state of Florida is for a three-story and higher condo is the structural integrity one. Beyond that, unless your documents require, which I'd be surprised, we usually don't see that kind of specific requirement. Then it just comes down to, what is good practice? I would say every 2 to 4 years is when you want to have a reserve study done. You want to stay on top of it so you're not especially you don't want to be underfunding, right? If you're overfunding, you can deal with that a little bit easier, right? But there's no legal requirement though for how often aside from the structural integrity reserve study. How will a physical location during video conferencing be enforced? That's a good question. So the way that I would see that being played out, I could see a couple of things. One is somebody could file a complaint with the DBPR if they're aware that there was a video conference meeting held without a physical location. The DBPR can investigate that. They can fine the association. Um, there's also the way of possibly going through arbitration for the owner. That is one of the disputes that needs to go through arbitration before you can just go ahead and file a lawsuit or go through pre-suit mediation. But potentially, what could happen is the decisions that were made at an improperly noticed meeting, which is really what this would be because you didn't have the physical location or improperly held meeting, I should say, is that a court could or an arbitrator could potentially invalidate the actions that were taken at that meeting. That's why it's so important to make sure that we don't trip up, if there's something, substantive that's being done that we don't, we're not tripped up on failing to have a physical location there. Video conferencing, the recording maintained for 1 year, does that include HOAs? No, I would say not yet. It wouldn't surprise me if that went into law, but no, that's not a legal requirement right now for HOAs at all. So there's a question, if we have a phone meeting, not a video, do I have to record the meeting like I'm required to record a video meeting? No, you exactly hit on, I tried to bring it up before that the statute keeps using video conferencing. It doesn't say any virtual conferencing. So technically, if you have a phone meeting, there is no recording requirement for that or a physical location requirement for it. Now, is it good practice at least to have a physical location for it? I would do it, just so that there's no question about it. But there is no requirement for a phone meeting to have it recorded. The only thing I will say, though, that's already been the case is that if you are voluntarily recording a meeting, even if it's solely in person, there is a requirement to maintain that recording at least through the time that the minutes are recorded. And that's always been the requirement. This is just adding the requirement for a video conference meeting that you record it and keep it available for at least a year. If we plan to use Zoom for the annual meeting, does the board still need to have a resolution as the not-for-profit statute states? So, um, I'm not sure if I fully understand that, Gene. It if you're going to have the Zoom for the annual, you don't really need the resolution so much as you have to have at least a quorum of the board members physically present at that annual meeting location. That's the requirement for that. If you're talking about the balloting and the electronic voting part, you're just required to designate the email address for people to submit their ballots electronically if you don't already have electronic voting. John said, for HOAs, can items be added to reserves without an independent backup report? Yeah, as long as you have the ability in your documents, which usually documents are pretty open for the board at their discretion to create reserve accounts or to add items, that's certainly within your authority. It's rare that you're going to get in trouble for adding items and reserving for items that are legitimate association expenses, that you're not going to get in trouble for that. Now, if you did it for something completely outside of what the purpose of your association is, and like I don't know, buying a beach club membership for only the board members or something absurd like that, right? I mean, that's not certainly not an expense. But if it's something where you're realizing, hey, we've got some deferred maintenance items, we don't really have a reserve account for that. Can we add and create a reserve account for it? Yes, and you don't need to go out and get a report right there. Eventually, you're going to want to have it so you know what your funding should be, and that's the best way to base your funding off it. But I wouldn't worry about creating it and using your best efforts to understand what you should fund until you get that updated reserve study done. Is email ballot voting limited to only elections, or can it be used with any voting done? So that only is talking about balloting for the election itself. If you're not going to be voting, if it's going to be like any other owner vote, like for amending your dockets, anything else that requires it, then you would go through the same process of limited proxy or showing up in person and casting your vote that way. Oh, I saw this too late. Somebody asked me to slow down. Sorry, I'm trying to make sure that we're getting through everything and answering your questions without keeping you too long, so apologize there. If switching from a straight line to pooled reserve is a member vote required to change is a member vote required to change the current straight line funds? I know that a board vote can be done for funds received moving forward. Let's see. No, what the statute says in a condo is that if you're switching from straight line to pooled, that is done by a board vote. A member vote is not required. Do structural and non-structural reserves need to be kept in separate bank accounts? Yeah, generally, you're not going to want to have those be able to touch anything. They have to be accounted for separately, and yes, those would be in separate accounts. If the board chooses to move to pooled reserves, if there are carryover funds from the line item reserves, can they simply be added to the pooled account the following budget? Yes, I mean, it's a good question for your CPA, but everything you're saying sounds correct in terms of carryover items from the line item. The way that I understand it is if, let's say, you had $500,000 worth of reserve funding over five components, $100,000 each in their own separate line item accounts. What you're then doing is putting all that $500,000 into one pooled account that can be accessed for any of those five items whenever you may need it. It says when you're using the term account for the reserves, are you referring to a line item in a budget or a separate bank account for each line item? So when I'm talking about at least keeping pooled reserves, and I think I just answered this versus the non-pooled, those should be in separate bank accounts. Okay. In terms of how the line item reserves, I believe those are also separate bank accounts too. Each have their own when you have a straight line component. That way it kind of flows within the theme of I can only use funds for this purpose. There's no way I could accidentally take money out from it. I would literally be short because I can only access funds for this item. And if I were to touch another one, it's going to be shown coming out of that other bank account. I would need to have an owner vote for it. That's where it's so strict on the straight line, reserves and the why it would normally be an owner vote unless you move to a pooled account now, which doesn't require an owner vote. Does a line of credit with a financial institution count towards the required structural reserve amount? So yeah, that's Ronald. That's what we were just addressing is that's one way that you can show compliance. But you need to then, if you do that, you need to go back and update your reserve study to show that you have that line of credit. That's one thing I wanted to mention is that if you're going to use that one of those alternative methods for funding it, you're required to go back and get your reserve study updated to show, okay, this is how we're doing it rather than through our regular assessments through annual funding. We have a line of credit that covers this. So I would talk with your reserve analyst about that. Regarding online meeting video retention requirements, are any board or annual meetings with online attendance required to be recorded? So this is only for condos again. Um, if you have Yeah, if you have any type of, whether it's a board or an annual meeting, if you have a virtual, like a visual component, I'm thinking video, Zoom, Teams, whatever the case may be, you're required to record that. Hope I answered that. I think I was getting your question right there. Underfunding, not okay, but is overfunding reserves okay? I mean, relatively speaking, yes. I mean, certainly could some member come and, argue that, the board is not doing its job by overcharging us for stuff that, it's going against what the reserve, study calls for. I mean, yes, but those doesn't usually happen because it rarely happens where you are overfunding it that way, and you can always adjust your funding in the future. I've had that happen where people will have in their reserve funding and they'll get an updated study done and they'll say, hey, Ed, it looks like we overfunded and now it says that we don't even need to fund this reserve account for the next couple of years because we are so far ahead of the game. That's okay. That's where there's kind of the catch up there. Where we're worried about is underfunding what the study calls for without having a proper owner vote or if the statute requires it. That's where we can get into problems. Who is supposed to do the new SIRS if the owners want to do 50% structural reserves? Did the same rules apply to non-structural? Can you completely unfund non-structural? So I think the question is, one thing is for structural reserves, you have to fund them pursuant to what the minimum level is in that structural integrity reserve study. There's no owner vote, there's no board vote that you can do to fund less than that without being found to be in violation, of the state statutes on this. For the non-structural, reserves like pool resurfacing, repaving, and that sort of thing, you can vote to reduce or waive your funding. It now requires a majority vote of the entire membership to do that. It used to be a majority vote at a meeting where a quorum is met. So they've even made it harder to waive funding for non-structural reserves, but you are able to do that. You just can't do it for the structural. Those are kind of set in stone, basically. Does electronic voting impact the prohibition of voting via email by directors? So electronic voting in this context is for an annual meeting where it's a member vote. You can't electronically vote for board meetings. And the reason for it is just because board members can attend in any way as long as they're, there live and you can hear from them. But so that doesn't change that. Electronic voting is only talking about when there's a member vote. So elections, voting on amendments, that sort of thing. All right, let's see. There's one question. Our board and budget committee does our own reserve study. We hired a company, let's say 6 to 7 years ago, and they offered no information that was different than our study. We use their forms now and do it in-house. We're only 116 units and very well off financially. Is that okay? I'm not sure if this is a condo. Obviously, if it's a structural integrity, that's got its own requirement. You have to go through one of those qualified. Let's say you're an HOA or you're not in a condo that's 3 stories or higher. I would still want to, even if you know, unless you can show how you're basing your pricing on and everything else when you're doing your updated studies, um, I'd want to lean on having a reserve analyst in, but it's not legally required, right? If we're talking outside of the structure integrity, the main thing is it sounds like you have a good process that you're following for it. You have anything that said, hey, we've been doing this process and we realize we're totally out of whack and we were messing up, so we need to kind of bring in a professional on it. I think you'll probably be okay because again, the statute doesn't mandate it for anything outside of the structure integrity side. If you're going to need to have a special assessment for the structural reserve account for repairs or painting of the building, you must have a majority vote to have this assessment. Yes, that's what the statute now requires. If you're going to fund your structural reserve amounts by anything other than a regular assessment, it's basically saying you need to have a member vote. And where my comment was, well, what if the board's allowed to adopt a special assessment? Now you've just made it harder for them to meet their funding requirements. And that's kind of a gap that we have. It's kind of one of those things where it doesn't totally make sense, to be honest with you. Recent legislation, yes, this is House Bill 913 was the question here. If an HOA uses Zoom at a board meeting, do they have to post video on the website and keep the video for 1 year? No, this only applies for condos. Email voting option, this only is addressed via for condos. It's not for HOAs. Now, could you choose to amend your bylaws as an HOA to allow for this process? Yes, because there's nothing in the HOA statute that says that it must be, conducted completely secret, which is what the Condo Act is now deviating from. That's what the rule used to be. This is now changing that statute. For the HOAs, there is no such statute that says it must be secret. So you could amend your documents to follow this process if you wanted to. Are scanned ballots from owners automatically acceptable, or does the board have to approve such process prior to allowing this? Well, the only thing that the statute says is that you have to create an email address, and then as long as the ballot you receive meets the requirements of what the state statute is, which, has their name, I believe it's also their unit number and possibly the date. I can't remember. And then and we can get that for you if you need it. It's in the statute. And then that disclosure, there's not much more really for processing or verifying from there, right? It's kind of like, how do I know that this is this person's signature? Well, we're not expected to go through and hire a handwriting expert either. If it meets it on its face, then we have to accept it. If somebody can prove later that it was false, then, we can address the election, but it's not the association's obligation to verify further than that. One question was if you have a reserve study done, but you're not within the three. So let's say you're not a 3-story and higher condo. You don't have the structural integrity reserve study done. Are condos required to fully fund within a specified period of time? I mean, you're still required to put money aside. There's a question of what's considered fully funded, but you're at least required to put the baseline funding in place so that you're not short when those components come up. That's the main takeaway and what reserve analysts will provide you in a reserve study so that there is a plan to make sure that you have the money available when those components come up. Anything less than that funding, where there's going to be a shortfall at the end, that's when you can be in violation, even outside of the 3-story and higher, condos with their even more strict reserve funding requirements. Are interim non-on-site inspection reserve study updates required to be posted at the DBPR? I'm not sure about a requirement. I know that reporting is optional. I believe that condos were required to notify them. It is something though, just to double check. I don't think it hurts to upload that document though, because I know they have the ability for you to do that, but they've changed it from mandatory to optional from the last I saw on the DBPR page. Okay, so there is a question about 617, which is the corporation not-for-profit for remote communication. So that's the way that you could have some type of remote voting. And now it even opens the door on the condo side for taking votes, which is kind of mirroring that. You would have to have those processes in place before the meeting so that you can notify members exactly if you want to vote virtually, here's the process you have to do. We're going to have a registration process, everything. Work with your attorney to get those processes put in place and voted on at a board meeting prior to going into your actual meeting where that vote could take place. So this says on the hurricane protection responsibility slide, this sounds like the board will always reimburse the owner for the removal or reinstallation of hurricane protection. Is that correct? No, what that addresses is if your documents are silent on that. If your documents address it, whether it's an owner or an association expense, then your documents are going to control. That addresses the issue if your documents are silent on it and you've got to go through those homeowner installed items to get to condominium maintained property. That if it's silent, then the default is that the association, yes, is responsible financially. But if your documents will control if they specify it. So the question about 50% structural is for 1 to 2 years allowable by the law. Done. Let's see. I'm not sure about Nicholas, about your question here about 50% structural for 1 to 2 years allowable by law. Um, I think maybe you might be talking about the 2 years where you cannot fund your structural integrity reserve study, your reserves there, if your milestone inspection calls for it. That's the only thing I'm aware of. All right. Just a couple more questions and we'll get you all out of here on this Friday. Do email ballots count towards an owner quorum or do they have to send a proxy in addition to the ballot? That's a great question. What I would say though is it would really match what the language already is in the statute, which is for the purposes of an election, a quorum is not required so long as 20% of the owners cast a ballot. It doesn't say what type of ballot, so whether they're emailed or handed in or they're mailed in, or if you electronically vote. If you got that 20% number for a condo side, then you've met your quorum for the purposes of having an election. But if you have, let's say another, if you're going to have another vote, you do need to make quorum for, like I said, waiving your non-structural reserves or amending your documents. A ballot alone would not cover that. You need to have a proxy to make your quorum. Who can do reserve study calculations legally? I mean, the best place to look is a reserve analyst. There's a lot of qualified reserve analysts. They have certain designations through different trade organizations. That's who you'd be looking to do that. Diane, good question. So if the HOA you always give me good questions, Diane, too. If the HOA is not required to fund reserves per their association documents, but the developer chose to create reserve funding anyways, is the HOA required to fund reserves according to the reserve study? The statute says we do, but because our governing documents don't require reserves, are we required to minimally fund the reserves according to a study? So there's a distinction though with the timing here because the laws change where it used to be that if the developer created a reserve account, up until I believe it was 2021 that you would have to fund those as what are called statutory reserves. After that date, we don't have really a lot of case law on this as to how you treat formerly statutory reserves, which are those developer created ones. They became optional. I think there's an argument that there's a looser funding requirement on the HOA side after that law changed if the developer created it, but you're not obligated in your governing documents. But it's an issue that has not been fully litigated. So and I know, with your community, if there is something, if there's a question on that for your ongoing obligations, we would need to look at that further, but it's not something that we've at least seen settled from an appellate standpoint. Right now, the only statutory reserve that has the more strict funding requirements are those that have been voted on by the members. If it's a board created one, or now if the developer creates it and they choose to, those are less strict, but you still have disclosure requirements in your financials saying, hey, we have reserves, but they're non-structural. It may lead to a special assessment in the future. That still is something you have to do, even if you don't have the structural reserves. All right. And the last question was, what does, I think DBPA, I think it meant DBPR stand for, and do they have a website? Yeah, so it's the Department of Business and Professional Regulation. They do have a website. If you want to look it up, if you just Google DBPR, I don't know, I think it might even be, I think it's My Florida License. Let me see if I have it here. I can pull that up for you. It's myfloridalicense.com is really how you get to the DBPR website. All right. So take a look at that. What I'll do too, Kevin, is I'll send you links if there's a way to easily post those for associations that need to create their accounts. I can provide you with the links to that if that will help if anybody needs to reach out to you and have access, or please, if you would like to email me and ask me for that too, we'll be happy to provide that to you. Okay. All right. Thank you very much. Thank you very much for the compliments here and for attending today. Um, in terms of accessing a recording of this, I believe, Kevin, if you're there to let people know how they can access a recording of it, do they reach out to you, or if that would be emailed, I would just reach out to Vesta on that.
Yeah,
All
no, no,
right.
no. Don't reach out to me, Ed.
Okay.
Just kidding. Give us a couple days to transcribe this recording and get everything ready and up on our website, and then Monday morning, you can just go to the Vesta Property Services website, vestapropertyservices.com, and then in the menu section, you will see a section that says webinars. When you click on that, it'll have a complete recording of today's webinar as well as a copy of this PowerPoint. We will also send an email to everyone that has attended with that link and that information.
Yep. Great. Well, Kevin, thank you. Thank you to Vesta for putting this on. I hope everybody, there's some great questions from you all today. Try to answer them as best I could, and hope you all have a great weekend, and we'll see you at the next presentation that we do, okay? Thanks, everyone.